It's no longer a real estate issue. It's no longer a representation issue. It's a legal issue. And so the role of the practitioner in that particular environment is to remain calm because we know that emotions are going to be running rampant. To remain calm and escort them to the lawyer's office, for goodness sakes, because they need legal advice. They don't need real estate advice at that point. So to practitioners, rule number one, push it to the lawyer because the lawyer is the one who is going to represent the interests of the consumer at that point. From a professional conduct perspective, I guess we're all wondering what is the standard setting governing body saying about reasonable care and skill in this environment, and I'm afraid that Mr. Ronde has already stole my thunder, and that's to say, yes, you have an obligation to discover facts, and one of the relevant facts that you might look for when you're representing buyers in a real estate transaction is whether or not the property involved is in a floodplain. And one of the amazing things we find out of tragedies and extraordinary circumstances like this is new resources. And so the Office of the Registrar did some research to go beyond the city records and the municipality records and so on and so forth. And you can write this down, it's envinfo.gov.ab.ca/flood hazard. And I'm sure that Lindsay's going to post that up somewhere so that everyone's got that. You know, it's the government of Alberta, it's the environmental services, and every lot in the province is mapped there as it pertains to the general flooding, the secondary flooding, the water flow from tributary to tributary, and so on and so forth. So along with the resources you've already identified, there's a new one now, and it's current right up till the end of 2012. And so, yes, you have an obligation in terms of reasonable care and skill to determine whether or not the property that you're going to assist a buyer in purchasing is in fact in a floodplain. I can tell you in conclusion that some of the steps that we've taken, in addition to our blog, we've spoken with brokers who may have had their ability to file their annual audit reports impacted because of flooding in the brokerage, perhaps flooding in an accounting office, so on and so forth, to contact us. We will be prepared to grant an extension in extraordinary circumstances. Our Consumer and Information Services Department has already fielded calls, and they fielded calls from consumers and real estate professionals alike. So again, I've spoken about how they're responding. Our Education Department, again under the auspices of the Registrar, is now including some of that floodplain information and locating flood information in our pre-licensing program, in our practice of real estate education program, and quite probably in our relicensing program that will be unveiled for 2013-2014 for real estate practitioners. And then finally, we're happy to field questions and attend forums such as the one that has been assembled here today. So thank you for your kind attention to my portion of the presentation. And I'll turn the microphone over to good Dr.
Becky introduced me. Thank you for inviting me. I've been asked to talk to you about building codes and remediation efforts. And well, building code is not probable, it's black and white. So it's very clear that the building code is very specific about what it is that you've got to have in your building. But after teaching for 35 years at the University of Calgary, I've learned how to make it simple. Is that they're simply buildings and water don't mix. There you go. You know everything about the building code. So the building code stipulates that if you design a building and build a building, you cannot have water getting in, regardless of whether it's rain penetration, or whether it's condensation, or rising dampness, or sewer backup. You've got to take measures to make sure you design it to prevent those things from happening. Now, of course, the building code applies to new buildings, and of course, this topic is about what happens after a flood, which means the building already exists or maybe just finished construction. The building code does not apply to existing buildings, only to new buildings. Now, of course, the proviso is that if you're going to do some major renovations to the building, then the building codes apply. So if you're going to do some structural changes because you've got a flood in the basement, that compromises the structural integrity of that basement, because there's some telly post or some load-bearing wood frame that's in there, and you're going to have to make some changes or some alteration to it, then you may be required to go and get a building permit. If you get a building permit, then a whole bunch of things come into play, in which the safety codes officer might say, well, this is a structural change, mechanical change, electrical change. You're going to have to bring in an engineer, an architect. You're going to have to bring in certain trades that comes in to fix your electrical or mechanical or the structure. And so that's a decision that it's up to the authority having its jurisdiction, so City of Calgary. City of Calgary will determine whether you require a building permit or not. And actually, it's a very good thing to actually apply for a building permit. And yes, you have to pay for the building permit, $100, but it does protect you because you have done the proper procedure. You have gone through the proper process. The safety codes officer said, yeah, you can go ahead and do that remediation or renovation, and therefore then it covers you, which is really important. But then when you're doing the remediation, as it was alluded to, is it going to be done properly or not? There's a heck of a lot of work that's going to be done here in the lower part of Alberta because of this flooding. There's going to be probably a couple of years worth of work. And there's a lot of people coming in from all over Canada to help out, to make a living, doing this kind of work. And you have no idea about their capability, their quality of the work, their background. Difficult to check because it come from a different part of Canada or maybe a different part of the world. And so yes, you can go with, the homeowner is going to phone up somebody, look at the yellow pages or whatever and say, okay, contractor, could you come and fix my basement, get rid of the water, repair it. But how do you know it's going to be done properly? Anybody can call themselves a contractor, just need a business license. And whether good or bad, it's variable. A lot of them are very good. There are some that may not be very good. So one way to protect yourself, if you're a homeowner, is to have a professional involved with that. Bring a house inspector, not a safety codes officer. There's two different things. What we call inspectors are not from the city. They don't want to be called inspectors. They're called safety codes officers. And basically they look at applying the building codes to new buildings and so forth. You look at a house inspector, which is another organization that specializes in looking at buildings and what needs to be done to fix them up and so forth. That's one type of organization that you can solicit to help with your client to say, you need this other person to oversee the remediation effort, so that it's not just the contractor that's doing it right or wrong, but at least you've got somebody that would sign off on the work that's being done. Now, if you've got a more expensive home, you want something better than a house inspector, then you need to go to an architect or engineer, which of course, that comes under the Alberta's Act, just like a lawyer. They not just call themselves a lawyer unless they're registered and have the requisite training, education, and licensing and so forth, or doctors. Likewise, architect and engineer come under the Professions Act in Alberta. And they, of course, cannot hide behind corporation. They are basically liable. And if they lose the license, they can't practice anymore. So a contractor can come and go. Even a tradesperson can go, but a licensed architect engineer will have to have that one license for their life. And so if they sign off on it, you can go back to them. They sign off on the remediation effort that's being done, and if anything goes wrong later, you are not taking responsibility. You can go back to that person. Can we take questions now? Or
you need to have her speak up.
Oh, the volume, speak up, sorry, okay. And so it's really important that you look at, like everybody's saying, we need legal advice, don't give it, get a lawyer. Likewise, remediation effort is not that simple. It's not just putting a coat of paint, replacing drywall. You've got to look at how do you remediate properly, because if you don't do it properly, it's going to come back to haunt the homeowner, a prospective homeowner later on, when the modes start coming back. That's the main thing, is the modes that could be trapped in the building. If it's not remediated properly, it's not fully gutted, disinfected, cleaned out, and then rebuilt, it can come back, and then what do you do? What recourse do you have? So the message that I have with you, and I'll sit down shortly, is the whole question of disclosure, and you alluded to the professions and responsibility and so forth, is that maybe we need to also disclose. I don't know legally, and you can ask my learned legal colleague here whether legally you need to disclose, but morally I think you need to. It's just that if you bought a house that had some incident with it, would you prospective homeowners want to know whether something has happened in the past? If you bought a car, if it's happening in a crash, you know that. You can find out whether it's been a crash before you purchase it. Same thing with the home. If there's a flood in it, you want to know whether it had a flood, which may not be okay. It may be okay because if it had a flood and if it's remediated properly with the professionals involved and it's done and they sign off on it, then no problem. It's had a flood, but it's done, it's remediated properly, and you're off the hook. So that's a question I'd like to leave with you in terms of disclosure, whether you want to use that analogy of a car in a crash to have been disclosed, and whether a house should also have that disclosure. But if it has that disclosure, then you can also make sure that you're not held liable by having professionals involved. Thank you.
Thank you very much. Now we're going to open the floor for questions.
To the structure, is a requirement of building permits to do that? Well, let's say specifically, replace completely as it was. Rip it all out, replace everything as it was. Do they need a building permit to do so because it's not effective changes to the property?
Okay, the question is, if you're going to cut the whole piece and replace everything, whether you need a building permit or not. I think it would be better to ask the safety codes officer whether you need that or not. Sometimes they say that if it's more than $5,000, that was one criteria that was told to me. If the remediation effort is more than $5,000, you better get a building permit. But it varies depending on the safety codes officer, whether they would impose that particular guideline or not. It isn't, there's no standard in regards to that. The only thing I know that if it does affect the structure, then you do need a building permit.
If there's coverage through insurance, how can that be? How can that be provided if technically there is no insurance?
Typically, it's not available in any jurisdiction that I'm aware of. There are programs in the United States, the National Flood Insurance Program, where you can go and purchase the coverage should you require it. My understanding is that program went bankrupt quite a few years ago. In commercial insurance, flood is available. Vehicle insurance, flood is available. Now, there will be times when you'll find flood insurance on a home because it's a commercial risk. It's a revenue property. I have a number of clients who insure their revenue properties, and while they're very pleased to find out they also have flood insurance.
Legal?
I beg your pardon?
Legal? Revenue property?
Yes, legal revenue properties. As a matter of fact, I have insurance on my own. But the word generally not available does apply to homeowners, unfortunately. There was some talk circulated by one of my colleagues in Calgary recently saying that the only way for that to happen would be for the federal government to mandate it, whereby it becomes a requirement that insurance companies provide flood insurance. Telling someone how to run their business has never been a good policy. The state commissioner in Florida tried it once with respect to windstorm. There was a massive number of insurance companies that exited that state. Didn't allow for a competitive market. That said, if everybody pays for it, even those people who typically don't live in a flood zone and need it, contributes money to the pool, it's possible that something like that could be set up. But unfortunately, at the moment, flood insurance is just not a reality for homeowners. With respect to condominium corporations, which are also residential properties, and a lot of you are probably wondering about that, flood insurance is available because we treat them as commercial risks. We're actually insuring a corporation that, in most cases, you're looking at the developer, when they're funding it, building it, putting it together. They need builder's loans. They need flood insurance for that. Quite often we'll see that it's just simply a requirement in the bylaws. Again, as a commercial risk, it's available. And in case you're wondering, yes, I've had a number of calls recently from people who are either renewing a mortgage or looking to sell or looking to buy. And they've been asking for verification of coverage on these commercial condo corps. The amount of insurance, whether or not the flood does apply, what the deductible is, and we prefer furnishing those certificates to the lawyers for political purposes.
Well, listen, you know, there's many different circumstances that come into play. And so what I'm saying is every instance has to be looked at in terms of, is it frustration of contract or is it not? Is it a situation where the buyer wasn't able to perform even though the property was available to them? So it's impossible to generalize. And you know, that's where you involve the lawyers. Now I have to say one thing, I was keeping notes here, maybe this is not the right time to address it. The suggestion about an amendment, you know, I'm not a fan of that. Because if you have a situation where you have a contract that's already signed up and unconditional, presumably you have lawyers that have already been appointed by the respective parties. As a lawyer representing the buyer or the seller, I would have a problem if the realtor signed an amendment without consulting with me, because that could be prejudicial to one or the other of the parties in that transaction. You know, again, you might have a situation where one of them is entitled to walk, and now the amendment that was signed without my input might prejudice them from being able to take that action. So I would not recommend on deals that are already unconditional and are in limbo, I would not recommend that you have amendments signed without consulting with the lawyers on the transaction. I think that already gets into the realm of giving legal advice that could potentially create liability for you.
Would you not have your own legal counsel?
Is that what happens?
I would expect that would be the best choice.
No.
I think the best choice would be on an individual basis on that one, yeah. I understand your question, yeah. So I was going to take that. Oh, sorry.
What we inevitably see is a buyer saying, I disclosed that. Or a buyer's realtor saying to you, I disclosed that. And you may have a recollection of the conversation, but there's absolutely nothing in your files to back yourselves up. Zero. So we're now into a credibility contest, and you may or you may not win it. So keep in mind that you can get sued up to 2 years out. Most of you probably don't remember what you did last Tuesday at 10:02 in the afternoon. So when you get sued, you know, 23 months from now, and this comes up, you're going to have an awfully hard time remembering. So it's just food for thought, and hopefully it'll help you. Whatever you do, put written notes in the file. Mr. Kane is right on that one. Anything is better than nothing. We like emails.
Do you have any further questions for the panel?
We're hearing that there's a number of insurance companies, they're talking to individuals that had sewer or storm backup and are claiming that it's in the vicinity of a flood, so it's not covered. So if you can speak to that, if you've heard anything in regards to that's going to be something that's going to get covered or not.
With respect to the position that insurance companies are taking, again, it's a case-by-case basis. And it's also driven by the policy wordings. Some companies have paid claims for overland flooding with concurrent sewer backup in 2005 aren't paying them anymore because the wordings have changed. Where now you have a situation that if the sewer backup is caused by a flood, there's no coverage. Generally speaking, flood insurance is not available on personal insurance policies. A number of insurance companies are looking to determine whether or not there was any sewer backup that actually did take place, and some of them are more liberal than others, and they're finding that if there was sewer backup coverage, that they will look after the claim per se. Others where there's clearly no, where there's clear evidence of overland flooding that basically came in through the windows and not up through the drains, those are typically not necessarily going to be covered. But again, it depends on the position that the individual insurers are taking. Some insurance companies are better than others. I can identify them. For example, if you're insured with the Chubb Insurance Company and you have a problem, the chances of having it looked after in a way that you would like are better than others. But that's the Chubb Insurance Company. I'm not going to mention any others, but most, as I said in my earlier remarks, what we're generally looking for as brokers and advocating on behalf of our clients is we're looking for consistency among what the insurance companies are doing. Where if they look at a situation and say, yes, there's sewer backup here, it would appear to be sufficiently severe that we're going to pay the entire claim on one house and yet deny on the next one that's right next door. That could just go down to the adjuster. In that particular case, the insurance broker could advocate, or you could just negotiate with the insurance company. Typically, you would have your insurance broker deal with that. If you're looking for insurance advice and advocacy, you would come to a broker. when it comes to suing them, I would speak to my learned colleagues at the bar here. What was the second part of your question, or have I answered both?
The second part was more in regards to, so then if it is a storm or sewer, is that going to be stigmatized as flood property? That might be open to everybody.
Well, again, that's difficult to say. I mean, there's memories do appear to be short. If you recall, back in 2005, there was a lot of flooding along the elbow, and it would appear that a few years after the fact, there was still a brisk trade in those homes. People had seemed to have forgotten about them. When you're applying for insurance, typically you're filling out an application, you have to disclose previous claims history and so on and so forth. So if you had a sewer backup claim, yeah, you should declare that. If there's a new owner and they know nothing about it, again, the stigma is only going to last as long as people's memories do, I would suppose. I can't be any more specific than that, I don't think. Does that answer your question?
Yeah, does anyone else have any comments in regards to the second part?
So I'm not a litigator, however, we have a litigator in our office. We already have clients seeing us for this issue where insurance companies are not making claims. And I agree, there are some insurance companies that we see regularly are less forthcoming with respecting claims, and ones that are very good at respecting claims. Again, good idea not to mention names. But you know, generally, if there is storm and sewer backup, then the claim should be made and it should be respected. And as I say, we already have clients that we're representing. The courts do not like insurance companies who do not respect insurance claims. Like, insurance is one of these things that they just seem to hold a little bit higher than other things. And I will also say, because this is something that I've heard many times over the last week, it is never a good idea to commit fraud with respect to sewage backup by creating your own sewage situation. we have people giving legal advice to other people. Oh, just go do this. That's fraud, and you do not want to do that. You do not even want to go down there at all.
I understand there is some case law that says that if you have concurrent losses, being both a sewage backup and a flood event, that there are experts that can actually go out there and determine which happened first. And if the sewage backup is proven to have occurred first, there may be coverage. On the other hand, if it's proven that the flood came first and then the sewage backup followed, there may not be coverage. So it actually gets very technical and very detailed in those respects. So again, I'm not an insurance expert, but people should consult insurance experts if they have that type of loss, because again, they may be able to get help to prove their case and prove their insurance loss if they have the proper people on their side.
Many of the insurers are dealing responsibly with their clients, and if they see that there's severe backups, they're finding coverage as opposed to denying based on the fact that there was subsequent flood. It's very true that the courts do not like insurance companies that try and skirt the issue. They would really rather see them step up and be responsible and deal in good faith. I think that it's quite often a good faith matter with the insurers and dealing with their clients, as much as it's with the insureds dealing in good faith with the insurers and not trying to create their own sewage situation.
I believe it was Nancy that was saying that you should always get the assessor in, get it checked to see if you have no insurance, then you can apply for disaster relief. So every home should be assessed.
One of the things that we're looking for as brokers is to see if the insurance companies will actually step up and have a declaration within about the next 2 weeks. That's what indications are, that every person who's been affected by the flood will know within a couple of weeks from now as to whether or not coverage is going to apply in their particular case or not. If it doesn't, the insurers are also stepping up and helping people determine where to go to apply for government assistance, providing them with the forms, the websites, and that sort of information, so that if they can't help, they're not leaving them entirely without resources and without a place to go. So,
I'm wondering if we should put a condition in of being able to obtain insurance
No different than getting a mortgage, because you can't get possession unless you have insurance in place. So it's an excellent idea to make sure you have that there.
I wanted to add something else that we haven't really spoken much about. We did touch upon the condos, and the situation there. That probably will be the last great displaced population group, because I have come into possession of a list of issues that a particular building is dealing with in Mission, and it has a whole list of issues that they've got to deal with before they can actually allow people back into the building, and we're talking about potentially weeks or even months. So, I mean, just to give you an idea, their fire and safety system must be operational, the air circulation system must be operational, gas system must be repaired by ATCO, structural assessment of the building, elevators must be operational, of course, sprinkler system must be operational. I mean, they've got a whole, slew of issues, that they have to deal with. Those people are probably not going to be able to get back into their buildings, and I'm not talking about Mission, but even East Village. There's other areas along the Elbow River. That's going to take a long time, before the people can get back in and before those properties can be marketed for sale again. So, this is not going to be a quick fix. This is going to be an issue that's with us for a number of months to come.
Probably years, not just months. Any further questions for our panel? It's gone 3. Oh, Bill.
Thanks, Becky. Just almost as a summary, I hope. Moving forward, this is such a catastrophic event that nobody's got any records on how we should be proceeding from here. So as for us practitioners, what does the panel recommend moving forward? First, I guess, Professor Tang Lee, what kind of tests would you might want to ask for when you go to a house that you're not sure of? And also from the legal point of view and the insurance point of view, some kind of guidance for us moving forward into this, untried and unproven area.
Actually, that did happen in 2005. The Alberta government put together a commission to look at the flood of 2005, and nobody really know what happened to that. There was a report prepared, but nobody actually has seen it. But I think the CREB might be a good vehicle or organization that could bring a bunch of people together and say, okay, well, what is it that you could do given the circumstance? What lessons we learn, and how can CREB be able to help their constituents in anticipating what happens here? I look at it obviously from a particular very narrow perspective of building codes and remediation, but there's lawyers and insurance companies and so forth, and so it's truly a very interdisciplinary type of committee that you could form and bring something forward to the membership and see whether that's something that you might want to include in the practice as you do, including some things like disclosure and all the other things that we brought up today.
Is there a pregnancy test for a house? Like a one litmus test you would use?
I don't think you can be half pregnant. But, the thing, of course, is both health and safety. Safety in terms of safety for the occupants who's moving in, and health, which is it going to impact the future occupants that's going to have that can get back to the seller of that place and the previous homeowner.
I need to tell you, this is, because I lived in Lethbridge in 1995, this is my 4th flood of the century in the last 18 years. I guess technically it's sort of 2 floods of the century in concurrent centuries. But either way, the professional conduct around trading in real estate didn't change 10 days ago. And so again, what we would implore you is to hold yourself to that standard of professional conduct in all of your dealings going forward. This is and again, I don't want to minimize the catastrophe that occurred here, but in terms of trading in real estate, this is a good reminder of the things that you ought to have been doing and you need to continue to do going forward.
3 things. Full disclosure, no matter who you're representing, absolutely paramount to reducing your liability. As I said, you can't get sued for disclosing too much. Secondly, if you're representing a buyer, we firmly recommend you have a look at the REIX inspection report form. And perhaps more important than anything, I had mentioned in my opening remarks how astonished we were that we did not get one lawsuit out of the fires up at Slave Lake. We attribute that to a tremendous number of calls from the industry to us looking for advice and direction. We're there. You own us. We're your infrastructure. You pay our salaries. For heaven's sakes, we don't care how stupid you might think the question is. That might be the very question that prevents a claim or a lawsuit down the road. So if you walk away from anything in terms of REIX, we want to hear from you. You're not pains. We're in the business of trying to keep you out of a lawsuit. We like to think we're pretty good at it, and apparently we're going to test our mettle at getting a little bit better. Thanks.
Generally speaking, flood insurance is not available on personal property, personal homes. It's just not there. There's no market for it in Canada that I know of. Commercial insurance is quite different. These days, if you buy a commercial insurance policy from most insurance companies these days, they're going to just toss on a flood extension with a minimal deductible and charge $50 for it. That might not be happening anymore in downtown Calgary. The insurance industry has been automated to a degree because there's just so much information out there. Policies have become so broad. Insurance companies have just been tossing it on. They're doing similar things with earthquake in quake zones. In Canada, at least, certainly not in the United States. So I think what's going to happen is that the insurance companies are going to start looking at their flood maps again, and they're going to say, well, you know, if you've chosen to build in a floodplain, you're just not going to be able to buy flood insurance. So just for the record, you can't buy it on a house. And it may become a lot more difficult to purchase it on commercial property if it's known to be in a floodplain. Certain floodplains will qualify for insurance, but there will be rate and there will be deductible. There was an earlier comment about condominium corporations taking on high deductibles because they don't think that this is going to be a big problem in the immediate future. That's only partly true. For example, if you've got a couple of $100 million worth of condominium building, $100,000 deductible at the end of the day really doesn't amount to a whole lot. But that condominium that suffered a flood might find themselves not being able to get the coverage in the future. So just a word, don't be surprised if you see that trend starting to emerge and the insurance companies starting to underwrite the hazard again. They used to do it quite religiously. I was amazed to be able to get coverage on just about every downtown business in Calgary that I insure, and quite a few on High River. Whereas I can remember 10 years ago, what, you're on High Street in High River? Not a chance. I really had to scrounge around for an insurance company on that one. So I think that will conclude my remarks on that.
I hate to differ on this particular issue, but you can be sued for disclosing too much. And yes, you can. And that's one of the reasons why the seller property disclosure statement was eliminated, is that it was disclosing things that were irrelevant and that the seller was not obligated to disclose. AREA has a form called the Defect Disclosure Authorization Form. Many of you may not have ever had any reason to use it, but look it up, because if you're listing a property, which is in a flood zone, it's a good idea to have the seller document for you what it is that they're directing you, not only authorizing you, but directing you to disclose. So that if you disclose issues, you've got documentation that you were instructed to disclose those issues. Keep in mind, the RECA rules mandate that listing agents disclose material latent defects, but the client is entitled to keep secrets that do not satisfy that test. And if it's prejudicial to their resale value, they have every right to instruct you not to disclose those issues. Now, that's legally. Morally and ethically, you don't have to accept to act for a client that's not authorizing you to disclose, issues that you think, should be disclosed. You don't have to act for them, but you cannot disclose issues which go, do not satisfy that test without your client's clear, instructions to do so. By the way, you can also be sued for more than 2 years. In negligence, you can be sued for 2 years from the date that the negligence is discovered. And so in theory, lawyers can be sued 10 years after the fact, and so can you as industry members. Okay, if somebody discovers that you committed negligence in representing them, they have 2 years to commence a statement of claim from the date that they discovered that negligence occurred. So it's a very long time period. Secondly, in terms of representing buyers, I think that there is clearly the need to use property inspection conditions. Always. I mean, it's always a good idea to have a property inspection condition in a contract for buyers, no matter what the circumstance. But doubly so, if you're going to be, having a buyer potentially buy in an area that you suspect may have been affected. and you would probably want to insert additional conditions. Now we're talking about new contracts that are going to be signed up in the months and years to come. I would think it would be reasonable for you to put a buyer's condition in there that the seller provide to you all available documentation that they have concerning the remediation that they conducted if the home was flooded. And that would include the photographs and all of the paperwork and invoices they have, so that the buyer could assess for themselves or give as an aid to their professional home inspector that information to assist in the home inspection that's being conducted on the property. I think that would be quite legitimate. If the seller has no documentation, then the buyer really should think twice about buying a home, because then you question were there permits, and by the way, adding the requirement that they give you the permits as well, okay, in terms of any remediation that was done on the property. And if you've got a buyer that's really concerned, putting in that extra testing for air quality, and that could be an additional condition that you put in there, as a satisfactory air quality test, to the buyer. The insurance condition that was suggested, I don't think the suggestion was that it be conditional to getting flood insurance, which is impossible, but just being able to get insurance, period. A homeowner's insurance policy on that home, because you can't complete the deal without that. So I think that there will be extra due diligence that buyer's agents are going to have to do, and some of this is potentially going to become secondhand, as more of these transactions take place, and maybe there'll be other written information that you will be able to rely on down the road in terms of suggested phrases and clauses that we haven't invented yet, that will hopefully be produced. I know, area has a lot of resources available to you. I know the Calgary board does. So keep an eye out for new information as it becomes created and available to you.
Lou, before you move on, can you very quickly repeat what that disclosure form was that you were referring to?
Areas form.
Oh, the defect disclosure authorization form. And that document was created, by the way, at the same time that the listing agreement, seller brokerage, exclusive seller brokerage agreement was created, the listing form, where we inserted the questions about material latent defects. That form was created so that if ever you have a seller that checks off, yes, I'm aware of a defect in the property. By the way, I hope people recognize that's not the end of your job. If ever they check off yes, you have to follow up and ask, what is it? What is the defect? And then that seller, the defect disclosure authorization form, they would fill out, and they would give you express instructions in terms of not only what you disclose, but how you disclose it, okay? And there is a question that has never been fully resolved. Do you disclose it right on the private, remark information on the MLS? Do you disclose it only when an offer comes in, before acceptance occurs? There's a number of different ways to look at it, but nevertheless, you do have the responsibility to disclose material latent defects. And if the seller is authorizing you to disclose issues which are less than material latent defects, that's when you really have to document it. That they've directed you to disclose that information, notwithstanding that they may not have otherwise been legally obliged to do so.
Try and keep it a little shorter. If the question originally was, what should you take from this? As lawyers, just like with realtors and insurance and mortgage specialists, we're part of a community to help people buy and sell their homes. And we should be working with you, not against you, but we should be working in conjunction with you. So if things come up, make sure that you give us a call. And most lawyers who do real estate law in the city are not charging by the hour. If you have a question, we're going to address it wherever we can. We have an after hours number, we can give it to you outside, it's not the place. But if you, it is just so important to, as soon as something comes up and you have a question, don't, if you don't know, definitely don't answer to your clients. But seek out the advice from whichever specialist or expert that is that you require, legal side from the lawyers, and then help us to help your client avoid issues down the road, because it is always easier to fix problems before stuff gets signed than afterwards. So I know, Lou, you're there for your clients, we're always there. It's just really important to make sure we're working in conjunction with us.
I think, and I've probably spoken too much today, so I apologize for that, but the thing to take away from all of this, guys, is you're doing everything right in the fact that you're here and you're asking the questions. I sit here as a broker and I think, wow, this is the first step. We've got amazing experts, we've got the board, there are people that can help with everything that's going to come forward. So just keep asking the questions.
Marianne. Is that everything? Do we have any more questions at all for our panel, or are we about done for the day? I don't see any further questions. Anything further online? Lindsay? No? All right, really appreciate everybody coming. So that brings our information session to a close, and as I said, this session has been recorded. We'll be posting it on CREB link in the next few days so that those who were unavailable to be here can view it. And I'd like to thank each of our members of our panel for their contributions, and also thank you for your participation in the event today.